How does one file divorce in Virginia? I will explain with these points how someone can file divorce in Virginia. That does not mean that I advise you to do so. I'm not sure it's a good idea in every particular situation for someone to file divorce without a lawyer. In fact, in many, if not most situations, I think it is advantageous to have the help of counsel in obtaining a divorce in Virginia. So as I go along, I will also point out some of the problem areas that one might encounter in filing divorce. You do have the right to represent yourself if you choose to do so. The clerks at the circuit court are not allowed to give legal advice and won't help you and don't have forms for it, but there are form books available for your use if you're willing to spend the time and study to prepare the documents properly. Now, the first issue I have here is a separation contract or property settlement contract. This is not required for divorce in Virginia unless you're seeking a divorce after only being separated for 6 months and you have no children. If you're seeking a divorce based on being separated for a year, you don't need a separation agreement or a property settlement agreement, but you never really know for sure if a divorce is in fact uncontested unless the parties have entered into a written agreement and have addressed spousal support, the division of property, the allocation of debts, if there are children, child custody, child visitation, child support, among a host of other issues. And sometimes it's funny, spouses can discuss cooperating and discuss getting a divorce almost as if one of them might be posturing, and when in fact they actually are served with divorce papers or receive divorce papers in the mail, it all suddenly becomes very real, and that profession of cooperation and desire to obtain an uncontested divorce might change. The primary step then is the complaint. The complaint is the original pleading filed in the divorce case. You need to identify the parties. At least one of the parties must be a bona fide resident and domiciliary of the Commonwealth of Virginia for at least 6 months preceding the filing of the case. The second point is jurisdiction. Jurisdiction, there's a couple of different types of jurisdiction. There's subject matter and active jurisdiction. Any circuit court in Virginia can hear and decide a divorce case. The real question here, and I'll touch on it later in the service of process section, is does the court have the power to affect the property rights of the person whose rights you are attempting to affect? The third thing that must be included in the complaint are the grounds for divorce. What is the basis for this divorce? And finally, the final paragraph of the complaint is the prayer for relief. This is where you tell the judge what you're asking the judge to do. What do you want him to do? And you should include all the things that you want the judge to do in the prayer for relief. Now, once the complaint is filed with the clerk of the court and the filing fee paid, and sometimes they require that you also file at that point the official form VS4, which is an information form the state requires. After that's filed with the clerk of the clerk will issue a summons signed by the clerk. The summons requires the person upon whom this document is served to respond within 21 days of the service date or suffer the consequences of that. So once the process is obtained, the next step is serving that process on the other spouse. In uncontested divorces, we attorneys typically use an acceptance and waiver where the spouse receives the paperwork by mail. Of course, the lawyer can only represent one spouse, so he or she doesn't represent the other spouse, and that spouse may want to consult with their own attorney about signing this document that evidences the fact that they accept the service of process and they're not going to require any further notice be given to them although it's usually a good idea to do that nevertheless. Now, here also is where if one of the parties is a member of the Armed Forces of the United States in active service, you need to get a Service Person Civil Relief Act waiver also signed and acknowledged and put in the file to show that they don't intend to use that statute for their benefit, or they're waiving their rights under that statute. And then I also wrote acknowledgement here because in situations where one of the parties is not in the Commonwealth of Virginia and might be in a foreign country or some other place in the military service, there are particular forms of acknowledgements, notarizations that must be completed to be valid. So the standard notarization that might work in the Commonwealth of Virginia might not work if the person is in the State Department or the military and is overseas or abroad somewhere. Now, the sheriff or deputy sheriffs in the county or city where the defendant resides can serve process on the person. That's always permissible. Or the plaintiff, the person who's filing the complaint for divorce, can pay a private process server in some instances to serve process on the defendant. And this assumes that the person is not willing to accept service of process and waive notice. Now, in this regard, the type of service can be very important. The best kind of service you can get, and the slam dunk, is the person who's the defendant is a resident of the Commonwealth of Virginia, didn't leave the Commonwealth when the marriage ended, just happens to be residing somewhere else, and the paperwork is handed to them personally, and you have personal service over them. If that's not possible, it might be handed to a person who's in the household who's over 18 years of age, or even posted on the front door. And substituted service is a lesser form of service. Finally, Virginia does allow for service by publication. This is where essentially an advertisement or a notice is published in the newspaper or tacked to the front door of the courthouse informing the defendant that somebody is seeking a divorce from him. Now, the pitfall here in all this is there are really two sets of things that you might affect in a divorce case. One is the divorce itself, the marriage, a termination of the marriage. This is considered like a thing that you carry around wherever you move to, wherever you go. All you need is what's called in rem jurisdiction. The marriage is a res, and either spouse, if they move somewhere and they satisfy that state's domicile residency requirements, like the 6 months in Virginia, they can get a divorce. They can terminate the marriage. Now, the other part are the rights, the property rights specifically, support rights that accompany marriage, the incidents of marriage. And to affect somebody's property rights, you have to get personal jurisdiction over them. I'm not talking about personal service necessarily, but personal jurisdiction means the state has a right to affect that person's property rights according to constitutional due process requirements. And those are that the person has to have some connection with the jurisdiction so that in fairness, the person could be expected to be hauled into court there. Now, this doesn't come up when both parties were married, they lived in Virginia, and they just separated and stayed in Virginia. But if, say, the husband or the wife moves to a different state, or they both move to different states, the question is it fair for either one of them to affect the property rights of the other in the state where they're residing? And that court would have to have personal jurisdiction over the person whose rights they're affected. In Virginia, we have a long-arm statute. It's called a long-arm statute because the state can extend its long arms and affect the rights of somebody who's not in Virginia if certain elements have been satisfied. And it can be complicated. It's possible, and there have been cases where somebody goes to a different state they get a divorce, they get a judge's ruling on support or equitable distribution, or even if they didn't, by law in Virginia, if that's not requested in a case where you have personal jurisdiction over the defendant in Virginia, the defendant can lose those rights. So even though someone might obtain a divorce decree and it purports to affect somebody else's rights, if it doesn't satisfy those constitutional due process concerns, it didn't affect their rights, and that person may still request support or equitable distribution in the appropriate forum. Now, the next thing that's required after the defendant is served with process in the case is the evidence. Virginia requires corroboration to grant a divorce. It's not enough that the husband and wife want to get a divorce. It's not enough that the husband and the wife both admit whatever fault grounds were alleged in the complaint. You need corroborating evidence. Typically, this is somebody else who is a witness who can testify or sign a deposition or an affidavit supporting the grounds alleged and the jurisdiction and the rest of what's included in the complaint to allow somebody to get a divorce. And the final step is the final decree of divorce that is submitted to the court for the judge's signature. And this is where people sometimes run into trouble, and it's not funny, it's unfortunate because they've spent a lot of time and effort getting up to this point, and all of a sudden the final decree is returned to them, and the judge or the judge's clerk or the clerk of the court tells them, sorry, the judge isn't going to sign this final decree of divorce. And they don't know how to correct the deficiencies in the final decree of divorce. And in fact, it may not be the final decree of divorce itself, it may be some other step that's deficient. In any event, it's possible that at this stage the judge will not grant the parties a divorce or the plaintiff a divorce because of some defect. Most family law lawyers, or I shouldn't say most family law lawyers and divorce lawyers, many of them offer free initial consultations, and I encourage you, if you're considering filing divorce, to consult with a Virginia attorney and discuss your prospects for obtaining a divorce.